So without further ado, please help me give Dr. Jennifer Dysart a warm Zoom welcome.
I appreciate it very much. I started working at John Jay in 2006, and I often teach psychology and law, Psych 370. It's also Law 370 for a lot of students who take that course as a cross-listed course. And I've also taught introduction to psychology and eyewitness identification, all at the undergraduate level. And often students would ask, or I would talk about how I ended up with this career and this job and this, life, I suppose. So I'm just going to take a minute to talk about that, because I know there might be a lot of people who are still considering, like, what am I going to do? What am I going to be? Will the inspiration hit me, at some point? And so I'm just going to tell you my very brief story. So I started off pre-med in undergraduate studies, and I had never taken a psychology course before because it wasn't offered in my high school. And so I took intro psych as like an elective, to fill up my schedule. And it turns out I thought it was the most amazing thing I had ever been exposed to. Chemistry and I loved each other in high school, but not so much in university. So I switched, dropped pre-med and became a psychology major, in part because of a fabulous professor that I had, Dr. Ian Fraser. This was, let's keep this in mind, 1994, right, that I had him. And he just made everything seem so fascinating. Like, how could I never thought about this before or in this perspective? So fast forward a few years, I took all the courses that he offered. I became a TA for him, and it came time for me to do my honors thesis as a senior. And he took one student a year, and so he agreed to take me as his student. And he was a face memory researcher. So very typical cognitive psychology. Here are 50 faces, take a little break. Here are 100 faces. Which ones have you seen before? And I thought, it's kind of interesting, maybe, but given that I was previously thinking I was going to go into medicine and I was going to help people, I really wanted to do something more applied as opposed to the laboratory cognitive work that he was doing. So he said, look, just go out there and find something closely related to to face memory. And I went out and I found eyewitness identification. So that was in 1997 when I started doing work in eyewitness identification. So it's been, 24 years now since I'm doing that work. And then I just continued on. I just loved it so much. I continued on with my master's and PhD, all in the field of eyewitness identification, and ultimately ended up at John Jay in 2006. So what's interesting, around that same time, I actually also started consulting as an eyewitness identification expert, aside from being a professor. And when I first started, I was consulting exclusively in criminal cases. So defendants who had been identified by an eyewitness or multiple eyewitnesses who claimed they were innocent, mistakenly identified, and wanted me to go into the trial as a witness to explain to the jury or judge why it is that this eyewitness was mistaken. You don't have to believe they're lying or a horrible person. It's just they're wrong. And here's what the science says about all of that. And what's so interesting, I didn't realize at the time how important that consulting work would be, because, when you're a student and you're reading these papers and it's all research that your psychologist colleagues are publishing, you're really devoid of the real work applied stuff that I had so wanted to do. So when I started consulting in these cases, it reinforced for me how important the research was, but also was this little validity check. Like, are the things that we're doing in the lab realistic enough to be, considered by a judge and by a jury? Like, how can we improve upon the research? So it became this really fascinating cycle of going out there, seeing what the police were really doing. And in many cases, I would shake my head and go, there's no way we'll ever conduct a study this horrible, right? This suggestive, this bias. There's no way. It's so silly that something so bad would happen in an actual case. And yet I was seeing this over and over again. Fast forward a few more years, maybe 10 years or so, I started consulting more regularly in death penalty cases. So if you can believe it, there are a lot of death penalty cases in the United States where the primary evidence against the defendant is eyewitness identification. And so, I did a number of death penalty cases, both at the trial and then post-conviction, where they were appealing their convictions, still claiming they were innocent. And in the last 5 years, I've been working on the other side, and that is post-conviction civil litigation. So it may or may not surprise you, but we're going to talk about wrongful convictions, obviously. But many states in the United States, if you are wrongfully convicted and the state acknowledges your wrongful conviction and they release you from prison, maybe after 20 years, 30 years, 35 years, you are not entitled to any compensation from the state. So, oops, sorry, our bad. You were in there for 35 years. Bye. Right? If you are guilty, committed the crime, served your time, you get resources from the government. You might have counseling, you might have a halfway house, there might be a stipend, right? So innocent people actually get worse treatment upon release than people who actually committed the crimes. And so what do you do with your life if you have been incarcerated from the time you were 18 to the time you were 55? Cell phones didn't really exist at the time you went in. Computer, you don't know. Technology has changed. The world has changed. And how are these people to live? And so the civil litigation comes essentially from lawsuits, where the individuals who are wrongfully convicted sue now, often the police, the city, maybe the state, for compensation for all of those years they spent wrongfully convicted. So that's the side that I see now. And there are very few of us in the country who actually do that work. As far as I know, maybe a dozen people in the United States who are actively doing work in the post-conviction kind of civil litigation world. So it's taught me so much about what actually happens in cases and how we can improve as researchers and as psychologists to do work that's more relevant for the people who actually need it, right? So that's what I'm gonna spend some time talking about. So hopefully that little intro was useful and give you a perspective. And you should know that very recently, I've been getting the last year or so, maybe with COVID lockdown, people have been scratching their heads and thinking what to do. I've been getting more and more calls from prosecutors' offices who many have what's called a conviction review unit or a conviction integrity unit. And these are offices within the prosecutor's office where people who've been convicted, who typically are still incarcerated, will contact the office and say, I'm innocent, I really am, please reinvestigate my case, reinvestigate the whole thing. And the conviction review units will do that. And if they believe that the person truly is innocent, they will recommend that the conviction be vacated and that the person be released. And so I worked on a case in Brooklyn in 2017, a case, the defendant's name was Mark Denny. And the prosecutor contacted me and was very concerned about the identification. He had served 27 years in prison for a rape that he did not commit. And he was released. This past January, I had the fortune of being on a really great Zoom presentation with him, with the prosecutor, with the Innocence Project of New York, where we all talked about our involvement in the case and, you know, kind of like what long served justice looks like, right? When the system can ultimately and eventually correct itself, what does that look like? So that was a real thrill to be involved with that. All right, what I'm going to do next is I'm going to share my screen and I'm going to give you a PowerPoint presentation because I'm a professor and this is what we do. So what I would prefer, just so I can get through all of the, the points that I want to get through, if you have any questions, there will be time at the end. Just like write it down really quickly because memory fades with the passage of time. time, and we don't want you to forget any important questions that you have. So, this is what I'm going to talk about: how we can maybe prevent mistaken identifications, and some things that you can do as well. So I'm going to cover really quickly, how big a problem is this really? Like, how often do eyewitnesses make mistakes and why, right? So if we can figure those two things out, it would be extremely useful. And once we know why eyewitnesses make mistakes, the idea is that we might be able to reduce the number of mistakes that are happening, right? And that's the goal of the research and our work with the criminal justice community. And this is the last point: can we help the criminal justice system to improve and to prevent these mistaken identifications from happening, which ultimately often result in wrongful convictions? So I'll talk a little bit about eyewitness mistakes or errors in actual cases. So you may or may not be familiar with this statistic, but currently, if you go to the innocenceproject.org website, you will see that there are 375 DNA exoneration cases. They haven't updated their number in a little bit, and I do know that there have been a few since this 375. So it's definitely over 375 DNA exoneration cases. So what does that mean? It means that a person was convicted of a crime. After their conviction, the DNA evidence or biological evidence in the case was tested, and it excludes the person who was convicted of the crime. So we know that this person who was convicted is not the person who left the DNA at the crime scene. And so a shocking number, at least for me at least, is that of those DNA exonerations, 22 people who've been now proven to be innocent were actually convicted and sentenced to death, right? So huge mistakes potentially in the criminal justice system that we cannot come back from, obviously. What's also super fascinating for me and important for this whole talk and its relevancy in criminal justice is that what we now know is that eyewitness mistakes are the leading contributing factor to wrongful convictions in the United States. So about 70% of those 375 DNA exonerations had at least one eyewitness, and many cases actually had multiple eyewitnesses. And one case in point is a case, Kirk Bloodsworth, lived in Maryland. He was a veteran who was out, never the military, never been arrested before. Not only was he misidentified by 5 eyewitnesses, he was also sentenced to death for the rape and murder of a, I believe, 9-year-old girl. But luckily for Kirk Bloodsworth, he was exonerated by DNA before he was executed. The other thing to keep in mind is that, so these are the DNA exoneration cases, and they're very special and they're rare because of the type of evidence that has to have been stored for very, very long periods of time. And so DNA exoneration cases are not going to be happening in run-of-the-mill robbery, assault cases where DNA evidence is often not left behind. So eyewitness researchers have another way that we can figure out kind of the extent of the problem of mistaken and wrongful identifications and convictions. And that is, we can use the police. We can work with the police to go in and look at their files in what are called archival studies. And we go in with their cooperation and we can look at the types of decisions that eyewitnesses are making in actual cases. And when researchers have done this, we've looked at thousands and thousands of cases all over the world. And what we know, and this may shock you a little tiny bit, but of eyewitnesses in the real world, the actual criminal cases, not our laboratory volunteers or participants, but those in the real world, of witnesses who say, that's him or that's her, I recognize that person, they did it, 40% are wrong. So 4 out of 10 witnesses in actual cases who make a positive identification of the perpetrator are wrong in their identification. So we clearly know that this is a problem. And so the real question is, can we help the criminal justice system reduce these errors so that mistaken identifications don't happen to begin with, and then the subsequent wrongful convictions don't happen as well, right? That's the big goal. So you might think then, after I said all of that, that I think eyewitness evidence is worthless, right? I mean, my goodness, that's a lot of mistakes, 40% of witnesses making errors, but that's actually not true at all. And that's not my opinion. Eyewitness evidence can actually be extremely valuable, but there have to be some conditions put in place in order for that to be true. So I'm going to throw out an analogy of eyewitness memory and eyewitness evidence as something you may have not thought about before. And I say that because I give a similar lecture to judges and prosecutors and police routinely, and they have never thought of it this way. And they've been in the criminal justice system thinking about eyewitness evidence for a very long time. So here's the analogy. I want you to think about eyewitness memory as a form of trace evidence that is more kind of, analogous to, actual hard science, right, to forensic science. So what are some examples of trace evidence that I'm thinking of? Fingerprint, right, left by the perpetrator at the scene of the crime, maybe a hair that's fallen out the scene of the crime, blood, a footprint, right? This is evidence that the perpetrator has left at the crime scene, right? Trace evidence. But I want you to think about memory as another form of trace evidence. Instead of the perpetrator leaving it directly at the scene, the perpetrator has actually left the evidence in the mind of the eyewitness, right? They've left, it's not really an imprint, but kind of think of it that way, in the witness's mind. Now, unlike the other forms of trace evidence, like a fingerprint or a hair or a footprint, we can't directly collect a person's memory, right? So we have to come up with other ways that we can try to get to this evidence. We'll talk about some of those ways. So eyewitness memory and eyewitness evidence can be extremely valuable, thinking about other types of trace evidence, if the evidence was strong to begin with. For example, a fingerprint. A fingerprint can be beautiful, all the ridges, everything just absolutely wonderful, or it can be a partial print, it could be a smudge, right? And so the more clear the fingerprint is, the more useful it is in terms of the investigation. The same with the eyewitness. If they have a really strong memory, a great memory, then that eyewitness might be extremely valuable. The other thing that's really important as well is that the memory evidence is only going to be as good as the procedures that were used to collect it and preserve it, just like other forms of evidence. For example, back to the fingerprint, you need to be trained to lift a fingerprint, right? They're not just like, hey, you over there, on a crime scene. Have you ever done a fingerprint before? No, come on, never too late to learn. Here's some powder and a kit, right? Go for it. No, right? You need to be tested, right? Trained in order to be able to collect and test that evidence at the crime scene. The same goes for an eyewitness. So the people who are talking to the eyewitness and trying to collect information should be trained precisely on how to do that the best way possible. The other thing to keep in mind, also keeping along with the trace evidence analogy, is that memory is extremely vulnerable to contamination. You've seen on CSI and other shows, they put on the little booties, right? They put on hats and gloves, right? When they go into a crime scene to collect evidence. Why? Because you don't want to contaminate the crime scene. The same thing with the eyewitness's memory, right? We don't want to have the eyewitness talking to other witnesses before they're interviewed. We don't want the eyewitness to go to social media and try to figure out, who potentially committed the crime or learn information from other people. So contamination is a huge, huge concern. So generally, we're going to go through what it is that an eyewitness needs to do and needs to do correctly in order for the end result to be accurate. And there are a lot of steps. And a lot of steps means that there are a lot of places where things can go awry, right? So here are the steps, pretty similar to if you've covered memory, if you've taken Introduction to Psychology. These are, roughly equivalent to the stages of memory. So very first, the witness has to perceive something. They have to see something, they have to hear something in order for them to get the trace evidence. Then they have to store that information correctly. And at the appropriate time, they need to retrieve that information, right? You have to access it. And finally, something that's not really talked about in memory research, but the witness has to be able to communicate that information as well. And so that might seem kind of obvious, but if your witness is a child who might not have the language skills to be able to communicate specific description, or if the witness and the police officer who responds don't speak the same language, right? Communication can really fall apart here. So this is a last important step to consider in criminal justice. So I want to talk a little bit about perception. I'm going to go right to the very beginning. I'm not going to just jump in at identification procedures because it's really important to understand how we get to the end, right? We need to know all of the ingredients in the recipe. So keep in mind with perception that our expectations generally and our life experiences essentially influence the way in which you interpret your environment, right? So everything that's happened to you before will slightly influence the way you see something as compared to maybe a friend. So I'm going to give you an example. I'm going to show you a couple of images. I'm just going to ask you to say to yourself what it is that you see for the purposes of expediency, and we can leave more time for questions at the end. So on the next slide, I'm going to show you an image. You don't have to do anything. And then the following slide, I'm going to ask you to say to yourself what it is that you see. Okay. All right. So when I ask people what they see here, many people will respond that they see like a man's face, kind of all scrunched up. So let's do that again. Now, when I ask people what they see, many people say they see a naked woman looking over her knee. But what's super interesting, at least for a psychologist, is that those two images that I showed you and asked you to make the decision, what do you see, were actually the exact same image. But what happened in the first instance is that I primed you with a man's face. And now when you see the ambiguous image, you're more likely to interpret it as a man's face. And then when I prime you with the naked woman, you're more likely to interpret the ambiguous image as a naked woman. So I just want you to keep that in mind when you're thinking about multiple eyewitnesses to a crime, how one person might be interpreting a situation very, very differently than another witness. So if you perceive it and interpret it differently, of course, you're going to remember it differently. You're going to report it differently. And this is one of the reasons why we see with multiple witness cases, completely different reports about what actually transpired during the crime. All right. This is a little footnote, but it's important. And it's important because when we're talking about memory, and in particular eyewitness identification, eyewitnesses are often asked to provide a whole bunch of information and details. What did you see? What direction? Was there a car? How long did it take? How far were you? All of those memory-related important details are critical in a case. But ultimately, when the eyewitness is tested on their ability to recognize the potential perpetrator, we have to consider faces differently and separately. And so the answer to the question, are faces special? The answer is yes. We actually do perceive faces differently than we do, for example, studying for an exam, right? Learning information and material. And I'm going to show you an example, actually, of what that looks like. So I'm going to show you the face of a famous person, and it's going to be upside down. It's only going to be on the screen briefly. And I just want you to say to yourself, if you think you can, guess who it is, say that name to yourself. And then I have some questions for you. Who was that? Hopefully you have accurately reported that is former President Barack Obama. Congratulations if you recognize the former president. Now, another question, did anyone notice anything unusual about his face? And again, this is rhetorical, no need to jump out and answer anything, but to yourself, did you notice anything unusual about his face? Of course, with the exception of it being upside down. Most people think, no, that seemed about right. I didn't notice anything. So I'm going to show you that exact same image I just showed you right side up. Okay, that's the picture that you viewed of Barack Obama. Now, you could probably see now that his eyes are upside down and his mouth is also upside down. For those interested, this is called the Margaret Thatcher effect. But what's so interesting is that we process faces holistically, not in little piecemeal individual features. So when I show you this image, again, right, I turn it around again. For most people, this image looks fine. In fact, you could just like turn your head. You're like, yeah, it is the bad one, right? In order to test yourself. But what's so fascinating is and again, this is like loosely putting it, but your brain kind of goes, oh, wait, there's some things wrong here. I know what a face is supposed to look like. Let me fix those things for you, to the point where you don't even see that these parts of the face are inverted, right? That they're the wrong way up. So this is in part goes to show you the kind of power and uniqueness of face perception for our brains, right? And that the brain actually processes faces in a separate, unique area of the brain in the hippocampus. So faces are special. So very briefly, why is it that eyewitnesses make errors? And this is important because if we can figure this out, then hopefully we can work to correct or prevent, right, these errors from happening, which is key. So since it's been almost 45 years now, since 1978 approximately, researchers have divided the field into two categories to make it nice and simple. The first is what we call estimator variables, and these are all of the factors related to the crime itself, the witness, the perpetrator, that we have no control over in the criminal justice system. And I'm going to give you a list of these so it'll be more obvious like what some of those are. And typically, these estimator variables are related to perception, the crime and the observation itself, before the police arrive, right, to do their investigation. And the second are system variables, and these are controllable factors. These are the choices that law enforcement make and prosecutors make when conducting the investigation to collect the evidence from the witness. So if these are choices that they're making, it means we can have reform, right? We can recommend practices and procedures that might increase accuracy and have a better outcome in these cases. So I'm just going to give you a list of estimator variables just to go through the list, and you think to yourself, oh yeah, I can see how that might influence the strength of the trace evidence, right? The strength of the memory. So first of all, we could have just errors in perception, right? Someone sees the face, someone sees the naked woman, right? So mistake in perception. Poor lighting can certainly influence our ability to see and encode information. If you only saw a perpetrator for 2 seconds versus 20 minutes, it's obviously going to increase the strength of the trace evidence, right? The strength of the memory. Really long periods of delay, right? Months or years between witnessing an event and then ultimately being asked to view faces or view people. If the perpetrator was wearing a disguise, like a handy COVID mask, a hat, sunglasses, all of those things work to decrease accuracy. When witnesses are extremely afraid or aroused after chasing after someone, perhaps, it actually decreases eyewitness accuracy. Intoxication is very complex. I did my PhD work, my dissertation on the effects of alcohol intoxication on eyewitness memory. But there's marijuana use, cocaine, PCP, a mixture of those things, all obviously can influence eyewitness reliability. There's nothing the police can do about it, right? Those things existed at the time of the observation. When perpetrators carry a weapon or hold a weapon, it actually decreases identification accuracy because witnesses tend to focus on the weapon. And when they're doing that, they're not focusing on the perpetrator's face, which of course decreases accuracy, right? The less time they have to see the face, and it also often increases fear when someone has a weapon on you. Cross-race or other group bias, we are less accurate at identifying people from other groups, with the exception of gender. It seems to not matter in terms of identification accuracy, gender. But we are less accurate at identifying people who are much older or much younger or from different racial and ethnic backgrounds than our own. It has nothing to do with prejudice or racism. We actually, it seems, start to process faces of people from other groups, not in that really special area of the hippocampus, but perhaps in another area of the brain. So researchers look at evolutionary perspectives and explanations for why this occurs. Distance. If the witness was really far away from the perpetrator, then obviously this is going to make a huge difference in their ability to see. And there are others. So as you can see, there's a whole host of estimator variables, nothing that the police or investigators can do anything about, but all of these things can serve to influence the witness's memory, right? The strength of their memory, and whether or not they ultimately can be reliable when the police get involved and start to ask them questions. So now we'll hit system variables, the place where we can make a difference, right? Where research has made a difference and will continue to make a difference. So system variables, again, these are controllable factors. These are choices. Sometimes it's a law. Sometimes it's just a policy that a particular state or police department will have. We're going to think right back to the very beginning. When a witness calls 911, the 911 dispatcher is often asking witnesses a whole series of questions about what it is that they saw. And they're also often asking witnesses to provide a description of the perpetrator or perpetrators. So this truly is, in many cases, the first opportunity to collect the eyewitness evidence. Therefore, it's also the first opportunity to contaminate the eyewitness evidence. And so the research that I've been focused on for the last few years has been specific to 911 dispatchers, and I'm working with dispatchers to help try to improve their evidence collection procedures. So it's going to start at the beginning. The next area is crime scene control. So once the police arrive, it's their responsibility to make sure that witnesses do not speak to other witnesses at the scene, what we refer to as co-witness contamination. The reason for this is it's often difficult for people to remember the source of their memory. Remember the gist, kind of the information, but often we can't remember if we saw it ourselves, we learned it from someone else, or maybe even both. And it's important that witnesses testify in criminal procedures about the things they witnessed themselves and not something they heard from someone else. That's called hearsay, right? And we don't want them to testify about those things. Next, witness interviews. What are the types of questions that police and other investigators are going to ask the witnesses? And psychologists have been extremely valuable and helpful with respect to procedures that are recommended for witness interviews. For example, something called the cognitive interview is based on scientific research that demonstrates that if you ask questions in a particular way, that you're going to get more information and more accurate information from witnesses in criminal cases. Many police officers around the country are now trained in the cognitive interview that was developed and researched, obviously, by psychologists. Finally, we get to identification procedures where, besides 911 calls, where I've been focusing my research for the last 20 plus years. So here are some of the different procedures where law enforcement need to be trained and where psychologists can actually help improve the accuracy. The first is show-ups. You may or may not be familiar with show-ups, but this is a procedure where when police arrive on a scene, usually fairly soon after a crime has occurred, and they look around the scene for, or in the neighborhood, in the not too far away, for a person who matches the witness's description. If they find someone, they usually hold that person and then bring the witness to that potential suspect to see if the witness recognizes that person. Now, as you can imagine, it's very suggestive, right? You describe someone, it's usually vague. 911 dispatchers are not trained to get very detailed descriptions. So it's going to be a pretty general description. Police stop someone who matches that general description. They're holding them, bring the witness. Is that the person that you saw? Right? So it's extremely suggestive with respect to who the police think might be the actual perpetrator. And research shows that there are a lot of mistakes with show-ups. We learned a number of years ago, so I'm not sure how accurate this information is any longer, but we learned that show-ups, researchers learned that show-ups happen with the NYPD in New York City about 1,000 times a day. So show-up identification procedure, very popular in large cities and jurisdictions. Next, we have mugshot searches, and this is when police do not find a suspect in the immediate vicinity. What they might do is have the witness come down to the police department and look through hundreds, if not thousands, of photographs where people have been previously arrested to look and see if this person who the witness saw had been arrested before and the witness will recognize them. It's been implicated in many DNA exoneration cases because essentially the witness can become overwhelmed by the number of options. And what the research shows is that witnesses often eventually choose someone. from this procedure. And that's not what we want. They're also all potential suspects because police do not know if any of these individuals had, an alibi, right, or not during the time of the crime, and so therefore they are not recommended. But they are used routinely in New York City by the NYPD. The next are composites or sketches. Composites are generally computer generated. Sketches are often with an artist. And I often see these in the subway system. You'll see the wanted, sign and some sketch, right, that's been drawn out and asked, if you see this person, please call Crime Stoppers. The problem with composites and sketches is that it's actually very difficult for witnesses to create a composite or a sketch, and they often look nothing like the actual perpetrator. So they can often lead police down the wrong path. Another interesting note, of all of the DNA exoneration cases that involve eyewitnesses, composites are involved in a quarter of those cases. So 27% of all DNA exonerations with eyewitnesses had composites. And this is shocking to people like me because composites and sketches are not used very often in routine police investigations. Finally, almost, we're at lineups and photo arrays. And for the rest of the presentation, I'm going to use lineups. But when I say lineups, I really mean photo arrays or lineups. So lineup is a live lineup, typically, where police have the suspect in custody, and then they'll go and find other people who look similar to that person and put them into the live procedure. And a photo array is simply photos of the suspect and the other individuals in the array, known as fillers. The last procedure, potentially, is in-court identifications. So this is such a frustrating procedure for researchers and scientists because often at this point, when a suspect becomes a defendant and they're now in court, perhaps for a suppression hearing where they're trying to have the identification thrown out, right, or dismissed from the trial, or at the trial itself, prosecutors very often ask the witness if they look around the courtroom, do they see the person who committed the crime? Now, very typically, the defendant is sitting at the defense table with the lawyers, and it's obvious who the defendant is, other than, aside from the attorneys. Often by this point, the attorneys have objected and spoken, right? So it's definitely not that person, right, who is the defendant in the case. And so it's silly. It's a silly theatrical, made for movies, My Cousin Vinny type of moment. But jurors often see the in-court identification as like a culminating, very important piece to the puzzle. Yes, the eyewitness may have selected someone from a photo array a year ago, but today, in open court, in front of all of these witnesses, the witness points the finger to the defendant. And that's an important, kind of lock or nail in the coffin, so to speak, on the case for them. The problem is that it's extremely biased, very suggestive, and it's also been preceded by many exposures that the witness had to the defendant, right, in the photo array or live lineup or other identification procedure. So not recommended. Interestingly, I believe in part based on the scientific research and recommendations from researchers, the state of Massachusetts and the state of Connecticut rarely permit in-court identifications at trial any longer. They see that it means nothing. There's no value to that type of information and evidence, and it's extremely prejudicial for the jury. So at least 2 states now have decided no more theater with the in-court identification, or in rare circumstances. So we get to the heart of it, because lineups or photo arrays, again, we use those interchangeably, really do make up the bulk of eyewitness identification procedures. It's the most common identification procedure that police use in an investigation. So it's important for us to think about, why are they doing this? Why are you showing a photo array, or why have you put together a live lineup to show the witness to begin with? So we ask ourselves, well, what's the purpose of this thing? Well, the true purpose is that the lineup is actually a memory test. Because remember, the eyewitness has the evidence, they have the information up here. It may be weak, it may be fuzzy, it may be clear, but the eyewitness has the evidence here, which is the recognition information we're looking for. So it's a memory test to see if the eyewitness can recognize the correct answer in the photo array or lineup, if that correct answer is actually there. So one key question, or one key point that law enforcement are supposed to say to the eyewitness before the identification procedure happens is very, very similar to a multiple choice question on an exam where the professor puts none of the above, right? You probably all hate that question. Professors love that question. Why? Because it's harder to guess. You actually have to know the answer a little bit better, a little bit more in order to be accurate, right? You can't just guess A, B, C, D. You have to know, is E, none of the above, truly the best response here? So it's a memory test where it's possible that the correct answer to the memory test is none of the above. And at the end of the day, what the outcome of the identification procedure does is it gives police more information than what they had before, quite simply, right? That, wow, this eyewitness seems to believe that our suspect looks like the perpetrator or is the perpetrator. Or the eyewitness says, nope, it's definitely not any of these people here. That provides law enforcement with a lot of information about the person they believe committed the crime, the police suspect. So extremely important. It's also important to keep in mind that this lineup, the photo array, because it's supposed to be a memory task and a recognition task, it's not meant to be a guessing or reasoning, kind of thing for the eyewitness. So they're truly supposed to be able to recognize the person, and you shouldn't be able to guess who the suspect is. Let's see if you can do it. I'm going to give you an example on the next slide. Just let me know, does anyone jump out at you as a potential suspect? Everyone just jump off the page. Well, if you said number 5, congratulations, you picked the police suspect in this identification procedure. This is from the state of New York. This is a real identification procedure. And in this case, the judge said, it's fine, no worries. Let it go to the jury. They can figure out if this was too suggestive or not. I have shown this photo array, I'm not joking at this point, to maybe 10,000 people. Every single person picks number 5. How is it possible that all of these people with no memory of the crime, no knowledge of the crime, can get the answer right? So this is not a memory test. This is a suggestive procedure that should have been suppressed in this case. So a couple of other points about lineups that are really important, and all of this does come from researchers, from my colleagues, and myself and others that do this work. Really important concept that is recommended, and in fact, the law, which is so fascinating, in over 25 states, is double-blind administration. And that is that the officer or person who's conducting the identification procedure is not supposed to know who the suspect is in the procedure. And all this means is that they can't really influence the identification outcome. They can't steer the witness towards the suspect, which makes the procedure more fair. They should also be given those instructions. The may or may not be there. None of the above is okay. If you really don't recognize anyone here, please tell us that. The other kind of important concept based on research is the size of the identification procedure. So there should be a minimum of 5 fillers. Those are the stand-ins, as other people, and 1 suspect per identification procedure. And the critical issue is to make sure the suspect does not stand out. This is supposed to be a memory test. We don't want to tip it off, right? Tip off the witness to someone, like the bad one we just saw. So I'm going to show you a couple of quick examples of standing out. In this particular case, this is not a case that I worked on, but have these slides from a colleague. The eyewitness described the perpetrator as an older white man with a beard who looked like he was homeless and had one eye. So if you take a look really quickly at the gentleman in picture in position number 1, you'll see he has one eye. Now, how difficult would it be for police to go out and find 5 other people who match that witness's description? Extremely difficult, if you ask me. So this is not the photo array that the police actually showed. This is the photo array that the police actually showed. excellent procedure, completely fair. And it turns out the eyewitness picked number one when they viewed this array. So the idea, which comes also from scientific research, is you can't just manipulate the photo of the suspect, you must change all of the photographs in a similar way to make it fair. All right. One other way in which a suspect can stand out from all the others is on clothing. And I'm showing this to you because I'm currently involved in a case in New York where this is the issue. And I just want to share this with you because I find it horrifying. Maybe you will too. When a witness gives their description, often clothing is included in that description. It's often a big part of it. And so what we need to make sure, we being investigators and police, is that the suspect should not be wearing the same clothes that the witness described, unless everybody in the lineup is wearing the same clothing. So if a witness said red t-shirt, everyone in the lineup should be wearing a red t-shirt, or no one should be wearing a red t-shirt. So I'm going to show you an example from this case, again, that I'm working on, where this is what the witness description was. You can read along. What's really important is the wearing a tan or beige colored jacket. That's the key. This is a live lineup conducted by the NYPD, and this is what they actually showed the witness in this case. Anyone jump out at you here? Tan or beige color jacket? That's right. Number 3 is the police suspect. Now, I think what the most shocking thing for me about this case is that they're all wearing jackets. Just take off their jackets. Why did you have people sit with jackets on? Unless the intention was to make this a biased identification procedure. However, the judge in this case allowed it in, the jury considered it, and they convicted anyway. He spent 14 years in prison. He's released, but still fights his innocence, for his innocence. Okay, so you can go a little too far as well. This is a case that I worked on in Connecticut, a post-conviction case where the witness said that the perpetrator was wearing a mask. And so police did almost like the one eye, you need to make sure you make it fair. And so the detective in this case actually took a black marker and drew masks on all of the lineup members. And so is it fair in that respect? Yes, it is. But it's also truly an eyewitness identification procedure. After 29 minutes of consideration, the witness was not double blind. The people conducting this procedure knew who the suspect was. After 29 minutes, the witness picked the suspect who's in position 7. Okay, so in my opinion, you can go a little too far with the match to description. So I'm going to just cover one last kind of bit of information with you, and then hopefully go through some time for some questions. And that is, the Supreme Court on eyewitness identification is wrong. They're wrong. And I'm going to share for you very quickly. I'm going to share these slides as well, so I'm not going to spend a lot of time on this. But the last time that the United States Supreme Court considered reliability was long before many of you, I'm sure, were born. It's actually before I was born. So 1977. And what the United States Supreme Court said was this: if we believe, like judges, so the whole point of this is that judges, once they get the identification procedure to consider, here's what they have to decide. Was it suggestive? Was it biased? If it wasn't biased, no problem. It comes in, the jury can consider. If it was biased, what they're going to do now is put the bias aside, kind of pretend the bias didn't exist. And then we're going to look at these reliability factors that the Supreme Court came up with in 1977. How certain is the witness? Did they have a good look? Were they paying attention, etc.? Right? Very reasonable things to consider. But the problem is, in order to exclude the eyewitness identification as being bad, you really have to pretend that the suggestiveness didn't occur. I'm going to show you why that's important. We know, I'm going to use eyewitness confidence as an example. So the Supreme Court said in 1977, fine. If it was a biased procedure, that's not good. But as long as the witness is certain, then we're fine. We're okay. The identification procedure is good. So a very typical set of identification procedures that happen with real witnesses is that they see an event, they do an identification, and then they're given some information about the outcome, like, good, you got him, or you don't have to worry any longer. You don't have to look over your shoulder. We have the person arrested, or we know now who did it. So in studies, what we do a very similar thing, but we manipulate feedback. So this is the independent variable that we consider. And so for some witnesses in these experiments, they're randomly assigned to get feedback, like, good, you got him. Or the control condition wouldn't be told anything about their identification. Then what we do is, as social scientists and researchers, we like, oh, oops, we forgot to ask you some questions. And these are really the critical things. These are the dependent variables we're interested in. Tell us about the event that you saw. Tell us about your identification experience, right? So after the manipulation, we go and we measure all of these things. Now, the Supreme Court says these are the things that are important, right? So this is what we're going to test to show the Supreme Court that they're wrong. What you see now in these blue bars, these are the control condition participants who did not receive any information about their identification decision at all. And what these bars represent are participants in studies who say, I'm absolutely, like, on a scale of 1 to 7, these are the 6 and 7s. These are people who are very high on the scale. So as you can see, only about 12% of people in the control condition were absolutely certain. One person thought they got a good view. One person thought the face was very clear in their memory. After they get the feedback, great job, you got him. This is what participants look like. 50% of witnesses now are absolutely certain. Not only that, they actually think they got a really great view. They think the face is really clear. It was a really easy decision. So the Supreme Court is wrong. When bias happens, when bad procedures are used, you can't pretend that didn't happen and then objectively, separately ask these questions. It's too late. The well has been poisoned, so to speak. And so they're absolutely wrong on their ability, on their reasoning for this, and it needs to change across the United States. So how are we changing it? How are researchers doing this change? And this is my last slide. First, research. But the key is that we have to publish, we have to conduct and publish relevant work that actually ties into real things that are relevant to criminal justice professionals or to theoretical advances in the field. It has to be comprehensible to people who need it. Psychologists are famous for writing in psychological terms and in fancy ways and very sophisticated data analyses. You may be familiar with that if you're reading primary research. But if lawyers are meant to read this, and police officers and judges are meant to be swayed and persuaded by the results of our work, we need to write our work and publish it in places where they can actually find it and understand it. So get involved in research, volunteer in labs, contact researchers and professors and graduate students if you're interested in this work. The other thing that's really key is training and education. I and other professors at John Jay routinely do trainings for police, prosecutors, defense attorneys, judges, policymakers, students, the media, and general public. A little plug from me and a colleague. We were involved last year on a series that was produced by, or I guess aired on Netflix, called The Innocence Files. And so getting the science out there for people in the general public is so important because those individuals are often going to become jurors. And if these individuals, fine, you became educated by watching a Netflix series, fantastic. You can use that information in the deliberation room, which is key. Amicus briefs are other ways to educate judges and others. These are policy kind of documents that are often signed on by a whole bunch of researchers to say, yes, we agree with all of these scientific conclusions. Legislation, writing to legislators, to a legislator who is considering passing laws on eyewitness identification reform to require police to do certain things or avoid doing certain things. And now over half the states require a majority of the best practices that scientists have contributed to and our knowledge of. And then finally, I do believe that my work as a consultant and doing testimony does actually help. It educates judges and jurors who take that knowledge on to other cases, to talk to people, to have media be interested in these wrongful conviction cases. And so that's another way in which we can change and help the system to prevent wrongful convictions. And that's all the time that I have. Sorry if I went long. I have a habit of getting excited and talking too much on certain points.
I thought you did great with the timing. Definitely enough time to open up the floor.
Great.
If anyone has any questions, you can either raise your hands or drop it in chat. I do have a question just to kick it off, just in case it takes a couple of seconds for the questions to come through. You talked a lot about reform, right? And so do we see this moving across the country in regards to retraining police and prosecutors? Like, how is that moving?
Yes, it is definitely a national movement. And as I said, I've been more and more excited, I guess, over the last year where prosecutors are the ones who realize that they need education on this as well. It's funny because, eyewitness memory, it's like, well, that's memory, right? For faces. And I do that all the time, right? I walk around, I go to the grocery store, the pharmacy, I see people, I go in the hallways, I see people that I know. What do I need to know? What do I need to talk to an expert for, right? People remember faces. Sometimes they do, sometimes they don't. But the truth of the matter is it's very nuanced and it's very complicated. And simple words that police use when they're interviewing a witness can completely change their impression of what happened, right? Going very briefly, going back very, very early research by Elizabeth Loftus, who's obviously, a key person in the memory field. She did simple studies where she would have two groups of people, and so randomly assigned to two conditions. And in one group, they would hear how they see an accident, car accident. How fast were the two cars going when they hit each other? And the other group would get the question, how fast were the cars going when they smashed into each other? Okay, hit each other, smashed into each other. Well, what does that conjure up, right? Like automatically, you're like, well, hit. So people estimated that the cars were going faster when they heard smashed. Now, that doesn't sound particularly relevant, but that might mean criminal charges against someone if the police now believe they were speeding versus hit, which might have just been an accident. In addition, she did a follow-up question and she said, well, did you see broken glass on the ground after the accident? There was no broken glass, to be clear, but people who heard smashed were significantly more likely to also remember seeing broken glass, because their schema, right? Again, to hit psychological terms, their schema of like what happens when two cars smash into each other is that broken glass is going to be on the ground, right? So it almost implanted a memory and changed the way in which they perceived an event by using one word, different, hit and smashed. So this is not, I don't think that's intuitive. I don't think people know that it could have those massive implications. So you don't know what you don't know. And the more you learn, the more you realize you don't know, right? And so education is key, and it's prosecutors are absolutely across the country just starting to realize that they have a significant role in preventing wrongful convictions as well, by deciding which cases to charge and go forward with, and deciding which cases just should not go forward.
Yeah, that's great. Another question, just because I don't really see any questions in the chat yet, and that's okay. You gave such great information. You had mentioned in the beginning that individuals who are exonerated, unfortunately, they don't get as much as those who are released, but they are able to file suit, right, against the city or the state or whatever the case may be.
Yes. Yes. In some states, you are automatically entitled to a certain amount of compensation. It's usually very basic. North Carolina, for example, is $10,000 a year for every year that you were wrongfully incarcerated. So I know someone in North Carolina who was incarcerated for 11 years, and he got a check for $110,000. Now, that just doesn't seem right? He clearly could have made more than $10,000 a year had he been able to have a job and study and go to school and all those things. So you're not. So some states have it. There are some states where the standard is $50,000 a year, but many states have nothing at all. So in order to, I think there are two purposes for suing, right? Civil litigation. One is to get compensation for you and your family. Many families get second mortgages on their home or take out loans to pay for the lawyer fees for 20 years of fighting your case. How are they to be made whole? They gave up jobs and careers and didn't move to another state or moved closer to the prison so they could visit you. They gave up too. And so this is a way to try to make the families whole as well. But it also serves to affect reform, because I worked, as a very specific example, I was trying to do a lot of work in Connecticut, and I lived there for a few years when I first started my career. And I wanted to do some educational seminars for the police. And the head of police training for the state said to me, "We don't have a problem here in Connecticut," because they did not yet have any wrongful convictions. They did not have any DNA exoneration cases at that time. And then they got one. They had a DNA exoneration that conclusively was not the person who was convicted. And then I let some time go by, and then I contacted him again and I said, "How about now?" And he's like, "Come on in." Right. And so it was, "Oh, it's not my problem," whatever. Until it is. And clearly there were more than one, there was more than one wrongful conviction before this demonstrative wrongful conviction. But it serves these, civil litigation serves to open people's eyes to this problem. And generally speaking, good people in criminal justice want to get it right. And until they're faced with the fact that they've gotten it wrong, there's no motivation to change. So the civil litigation certainly, I think, helps in that regard.
Thank you. And then you also mentioned being on the Innocence File. So I just want to throw it out there for everyone. If you haven't watched it yet, it's on Netflix. Definitely watch. And can you just tell us, before we go, again, the courses that you teach, in case students are interested in taking it? And I'll definitely drop it in chat as you're saying it, because registration is about to roll back around, everyone. So definitely keep Dr. Dysart in mind when you're selecting your courses.
Well, fantastic. So I routinely teach Psych 370 or Law 370, which is psychology and the law, and where we talk about this. And also I talk about false confessions, lie detection, jury decision making. So I'm pretty familiar with all of that literature and research as well, even though this is where I spend the time doing my own research in the field of eyewitness identification. I haven't taught intro psych for a while, but used to teach intro psych. And occasionally I teach Psych 421, which is a senior seminar in special topics, and I'll cover eyewitness identification. And if you're in the BAMA program or interested in that, I also teach Psych 700, which is also an introduction to psychology and law for master's students as well.
Awesome. And is it okay if you're open to it, sharing your email with everyone in case they wanted to connect with you?
Absolutely. It was on the very last slide. I think I'm not screen sharing anymore, so you can't see that there. But yes, please, if you want to put that in the chat or share it with people, absolutely. Feel free to reach out.
I'll email everyone who's here today, Dr. Dysart's information, so you can definitely stay in contact with her alongside. Let me just take a screenshot of these courses you just mentioned, just so I can make sure that I include that. But thank you so much, Dr. Dysart, for coming and sharing your expertise, your experiences. We so appreciate it. And thank you and everyone saying thank you in the chat. Yes, for encouraging students to just be advocates in a different way. This is definitely a different, unique way for sure. And hopefully we'll continue to see that reform happening. We're so grateful for you. Thank you.
No problem. I also teach in the master's program. I teach a whole semester, a whole course on eyewitness identification. So I did my best to try to put in the nuggets that I thought might be useful or spark some conversation. Go home, share whatever knowledge you learn in your classes. I'm going to give us some advice to students, unsolicited. Share it with the people in your life that are not going to John Jay or not sharing, the courses that you're in. There's so much valuable information from such great experts, distinguished experts from around the world, that you might take for granted all of this great knowledge that you get from your professors. And, if we're going to make change, the more people who know, the better, right? So I hope it's shared outside the classroom and with family and friends as well.